Bill Henshaw here again, Constitutional Crisis Channel. And this is current event, kind of a follow-up to a tape that we did recently on the removal of the CSA statutes in New Orleans, which, as you know, I have absolutely no use for that. I mean, that's destroying American history, which is the real agenda behind this. But if you're going to do that and go with the political winds that blow in any given direction at any given time, why not have someone propose that we take down statutes to people like Martin Luther King and civil rights leaders on the very good grounds you can very arguably say whether they're acting in good faith or not, the question I'm not addressing here, that they're advocating the overthrow of the government of the United States by military force, which is exactly what the 14th War Amendment did and is continuing to do 150 years later. That, it seems to me, is treason to the Constitution, and that's not something that we should want to encourage now, is it? And think about this, if we're going to go with those political winds, as I've been suggesting, why not in the future take down the statutes of George Washington and replace them with Benedict Arnold? Or even worse, Alexander Hamilton. I mean, this is the kind of crap you get into when you do stuff like this, and it's just history. I mean, he who controls the past controls the present, and he who controls the present, it's just how this works. And it's got to stop. The true history needs to come out, which is the main point I'm trying to make in everything I do here, is to get this stuff out, because they sure as hell aren't teaching you, and they didn't teach me 50 years ago. I had to find out on my own, and I put close to 10,000 hours into doing that, and I hope it shows. Things I'm saying here, I haven't heard any of these other gurus come close to saying. Not that they're not right about some things, but I think what I'm doing gives us the best chance to succeed against these bastards and turn things around and start to put some of them in jail for treason. How many do you think it will take before they get the message? And this one's kind of a continuation of the video we just did on the taking down of Confederate statues in New Orleans. And it's kind of an offshoot of it. But I hope you'll see it's connected, because I want to talk about what I consider a really infamous case, and it certainly isn't Scott versus Sanford, aka the Dred Scott decision. And we're going to do a video or two on that case alone in the upcoming feature. I've got several cases we're going to talk about. That was anything but infamous. They just don't want you to know the truth. One of the really infamous cases for me, aside from Carrie Buck versus Bell, which is a story for another day, 274 U.S. 200, is the case of Brown versus Board of Education in 1954, when the court ostensibly repudiated the separate but equal doctrine, and they had what eventually resulted in integration of all the schools across the country on a racial basis. But the problem with that is that they based it on Section 1 of the non-existent 14th War Amendment, and I can almost assure you across the board that all the justices at the time that were on the court knew better than that. The amendment didn't exist, and that's why they strove so hard to make it a unanimous decision. And if I might back up a little bit here, that might well not have happened at all, but for the very convenient death of Fred M. Vinson, the Chief Justice before Earl Warren. Now, I'm a conspiracy theorist. I mean, we all have probably figured that out by now. I don't know of anything remotely related to Fred M. Vinson as I do with John F. Kennedy, but it was just very convenient timing. And wouldn't you know, Earl Warren gets appointed to the Supreme Court, which takes him directly out of the political path of Richard Milhouse Nixon. I think that's the real agenda there, for what it's worth. That's another story for another day. Nevertheless, if Vinson's on the court, that decision comes down 6-3, maybe even 5-4, and it's possible it would have gone against Brown and in favor of the Board of Education of Topeka, Kansas. Now, the problem with this is the court was making it up ipsy dixit. I mean, just making it up out of thin air with no backing from the Constitution or whatever. And you can say the same thing, by the way, about Roe versus Wade, another case we're going to talk about later, where hip pocket Harry Blackman kind of did the same thing with not so serious consequences. But we will be talking about that case later, trust me. But the deal here is, I agree with T.S. Eliot, who said, a direct quote here, "The last temptation is the final treason to do the right thing for the wrong reason. And if you understand what they were doing by expanding federal regional martial law rule, and this was all over the country. Initially, yeah, it applied in the southern states. That's where most of the quote-unquote problem was. But it eventually expanded. You had cases out of Denver, Colorado, Detroit, Michigan, South Boston, where they had a lot of violence up there when they started busting those people out of those schools in Southie. It was not pleasant at all. And there's no constitutional authority for it. And the court bears a lot of responsibility for crap of this type. You know, the civil rights stuff that they knew or should have known better than to do something like this. There are much better ways to address this problem. And oh, by the way, you know, in my defense here, yes, I'm again advocating openly quote unquote right racist issues here. But if you do this properly, consistent with the Constitution, I think a much better result could have been achieved. And I'm somewhat aware because when I was raising, well, not my daughter, but my little sweetie who's now an adult, and we won't talk about that now, but we read a book called I Know Why the Caged Bird Sings. And it was an autobiography. And in there, you know, there was a lot of talk about the segregation in the schools in the 1930s in Arkansas in particular. And, you know, I got that. And I got how bad it was. And it was so bad that graduation day was the worst day of the author's life, where she had to suffer through, because that's the only time they would see the members of the all-white school board that would come, you know, and visit the black schools. And they congratulated the students, and with the notice that they did so well that the next year they're going to have 2 new basketball courts put in there. This is like in 1933. And this, by the way, is a book written by Maya. I think her name in a minute here, but I read this, and it's her story from Arkansas all the way out to California, where she spent some time in Los Angeles, went to San Francisco, and became the first black conductor on the system there, the cable car system. And it's a very interesting book, and I get it. I get how wrong that was, but you don't, you know, 2 wrongs, you know, don't fix a right here. And to do what was done with federal regional martial law rule should never have happened. It's just not the way the government was set up, and it just increases the power of the New York banksters there at 120 Broadway, New York, which is the real agenda here. Damn it, we just have to stop cutting this stuff out. And if we do that, now we get the races working together and not constantly fighting each other, which is exactly what was intended from the very first Civil Rights Act. And we'll talk more about that later, but you read the debates in Congress at a time when you had people of intelligence, passion, and integrity there, not like who we have in Congress in either house these days, and talk seriously about this issue. You should begin to understand what the hell was going on there and what the problem really is. Unfortunately, I never heard any of that in my civics classes, and I'm sure you haven't either. Once you do and the light comes on, you say, what the hell have we done here? And that's where I reached, you know, where I finally understood the state versus territory issue and what they really did with the 14th War Amendment. That's a subject for another day, too. But nevertheless, you think about these things in this context, and this is what has to stop. And the sooner it does, the better off all of us are going to be. And I mean across the board here, except possibly for illegal immigrants. And that's another subject for another day. But if you're here illegally, could somebody kindly clue me in by email what exactly the rights is that you think you have? I've not been able to find any. So I'll appreciate all the help I can get with that one. Now, a continuation of the Brown versus Board of Education video that we just did, and I failed to mention, as I should have, that Maya Angelou was the author of the book, I Know Why the Caged Bird Sings. And among other things that was mentioned in there, and I don't recall all the details, but she said that one of her family members, I believe her mother or grandmother, had occasion to loan a white dentist some money for some purpose or another. It wasn't specified. And when she later went in and took one of her, I think her grandson, into the dentist to get some work done, the dentist literally said he'd rather put his hand in a dog's mouth than a nigger's. Now, this is the sort of thing, and you say, oh my God, civil rights violation, 42 U.S.C. 1983. What you do in a situation like that, see, a dentist is someone who's required to have a license. I got that one. With the proper government in place, I agree with it. And if that's the case, when you get a license to do that kind of business, you're in business to serve the needs of the public. If they would have brought a case against the dentist for failing to do his duty, they could maybe have had his license revoked and put him out of business. And by the way, a good case if you want to take a look at this one, it'll be a little hard to find, but those of you who requested, I will send excerpts. I don't have the full case right now in digital form, but you look at a case called Re Meador, Meador, 16 federal cases, 1284, I believe is the site. It's a federal case from about 1865. And you look at what the court said in denying the Meador's claim against the government, because the government wanted them to produce documents and records for their business. And they said, wait a minute, Fourth Amendment here. Now the court said no. They said, in effect, when the Meadors got the contract, they volunteered into it and agreed to all the terms and conditions. And boy, I've got this one in my jury instruction file. It's a beaut, because this immediately defeats all the claims, for example, for driver's license, social insecurity, you name it, because there's a lot of hidden things there they never tell you about, which is why I made a rescission for cause of my application for social insecurity benefits. Because the Meador case said openly in there, it said when they applied for the license, the law was before them. It sure as hell wasn't for me, and it sure wasn't for you. When you read some of the things I'm going to say in my paperwork, and I may do a separate video on this, especially with social insecurity, all the hidden traps that you get into that you don't know about, that's fraud. And like any contract, if it is a contract, and by the way, the Supreme Court says, no, it isn't, you have no rights to social insecurity benefits. Flemming v. Nestor, 363 U.S. 603. The case will have a separate video on in case you think you got a right to it. No, you don't. This case is humongous. Had it gone the other way, it was 5-4. It goes the other way. It may have changed the course of American history. That did not happen, and I will tell you with a lot of specificity why it didn't. But this is the kind of remedy we need. Everybody can use it, and had they used this back in Arkansas in 1933, this dentist is going to have a real hard time making a living doing what he just did there. I mean, not only is that racist, but it's a complete violation of his Articles of Incorporation. And that's how you deal with people like this. Civil rights, forget about it, and about which more later. Thank you.